I was concerned with the particulars of the legal arguments. And I should say my answer to the media when asked, when they say, can the president pardon himself, is, well, he can try, because we don't know. No president has done it. At least one president has contemplated it, had his lawyers write up a memo about it, but we don't know. So my argument that the president can't pardon himself is basically my argument for if I were a judge hearing that case, why I would rule against the validity of a self-pardon. And there are three main parts to the argument. One is based on the text of the Constitution. One is based on some principles, you could call them common law principles. And the third is a historical or an original intent argument. And the textual argument is that if you pardon yourself, that's not a pardon. That a pardon is inherently bilateral. It's inherently something you give to someone else. Similar to if you give someone a lift to the airport, right? You can't give yourself a lift to the airport. That doesn't make sense. You could call it that if you drive yourself to the airport, but it doesn't make sense. That's not what it is. The Latin root of the verb to pardon, perdonare, has two other verbs that are derived from it, to condone and to donate. And both of these, too, I think you can say the same thing. You can't condone your own actions. It doesn't make sense. You can't donate something to yourself. It doesn't make sense. If you want to donate something to yourself, you have to set up a separate legal entity that you control and donate it to that, because you can't donate something to yourself. Pardons work the same way. The pardon power, getting a little highlight of the historical argument, the pardon power is derived from the royal pardon power the King of England had. The King of England never had any ability to pardon himself because the king could do no wrong. He had nothing to pardon himself for. So in the very notion of the pardon power, is this bilateral relationship between a sovereign and a subject. The second argument, what I call the common law argument, is based on two principles that judges base their decisions on when they follow these principles. When they don't, they conveniently forget them. So again, I recognize there are arguments on both sides here, but two important principles. Things that I would rule based on were I a judge in a case like this. And the first is the rule of law. The notion that a president could pardon himself, to me, is a threat to the idea that we are governed by laws and not by men. And the reason that it's a threat to the rule of law connects with the other principle, which is an old principle that no person can be the judge in his or her own case. And we see this elsewhere in the criminal apparatus. If you are accused of a crime, you are accused by a prosecutor, indicted by a grand jury, tried by a judge and a jury, perhaps pardoned by a president. In each case, you could not be one of those decision makers in your own case. You cannot be the prosecutor in your own case. They would have to find someone else to do it. You cannot be on your own jury. You cannot be a judge in your own case. Again, this principle, if we extend it to the president, would say if the president wants a pardon, he has to get it from a president other than himself, right? His successor as president. The Constitution has a lot of very specific provisions, and so sometimes people say, well, there's nothing specific that says he can't pardon himself. So why are we going to read this implicit limit in? And I would just note two things quickly. One, there are other implicit limits in the pardon power. One is, for instance, you can't pardon someone for something he hasn't done yet. You can't say, I pardon you for the bank that you're going to rob next week. You can't do that. You can only pardon things that have already happened. It doesn't say that anywhere in the Constitution. It's just implicit in the definition of a pardon. But there are also implicit limits, I would argue, based on this notion that a person cannot be a judge in his own case. An example of this, impeachment. The Senate is presided over by the Vice President of the United States. The Vice President of the United States is the President of the Senate. There is one exception to that. When the President is being tried by the Senate in an impeachment case, the Chief Justice presides. Because it would be a conflict of interest for the Vice President to preside over a trial, the result of conviction being that he would become President. So the Constitution substitutes the Chief Justice. So my question to you is, who presides over the trial in the Senate in an impeachment case if the Vice President is being impeached? If we say that the Constitution makes one exception, only if the President is being impeached, and other than that, the Vice President presides, then you have to accept that the Vice President would preside over his own impeachment trial. Now, maybe you accept that. Maybe you think that would be okay. I've heard it argued that it would be. But if you think the President can pardon himself, then you have to accept that result as well, that the Vice President could preside over his own impeachment. I think that is an example of how I would assume, of course it would be the Senate deciding for itself, not the court, I assume that the Senate would not allow that to happen because you cannot be the judge in your own case. That principle is deeply rooted in our structure of government enough that they would apply it, even though it's not in the Constitution. Finally, and very quickly, the historical argument. When the framers were drafting the pardon power, they did not discuss self-pardons. I would argue it's because they didn't think, they literally thought it went without saying that the president could not pardon himself. But they did discuss the possibility of presidents abusing the pardon power. And one of the things they decided to do was to give the president a broad pardon power with virtually no limits. And this was strange, because we had just fought a revolution against a monarchy because it was a monarchy, and state governors in the state constitutions that had been written to that point tended to have greatly reduced or weakened pardon powers. But then they came in and they gave the president this royal power. And someone argued in the convention, well, this isn't right. What if we eliminated the president's power to pardon in treason cases? Because what if there were a bunch of traitors and the president was using them? They were rebelling, they were working for him. The president is a traitor, and you're going to let him pardon all these other traitors working for him? We can't do that. And the response to that was, yes, we can. Because if the president does something like that, he can be impeached. And he can be prosecuted. That was the argument. And they voted and they said, okay, let's not limit the pardon power. Implicitly then, let's rely on impeachment and prosecution if a president should abuse the power that badly in the exercise of some criminal enterprise. If anyone in that room had thought that the president could pardon himself, that argument would not have gone unanswered, let alone carry the day. So although they did not ever say specifically the president cannot pardon himself, I believe the evidence shows that they understood that the Constitution that they were writing was not giving the president the power to pardon himself. That's as I said, long elevator ride, tall building, but that's the essence.
Let me ask you about this.